Good morning, everyone. Welcome to the third installment of my contract video series. Today, we're going to be talking about the inspection provisions of the NABOR contract. And I put on my screen 15, 5, 10, 5. We'll talk about those numbers later, but you might want to write that down. Because I am an attorney today, we are talking about starting off with a disclaimer that I'm providing you advice, but it's not necessarily legal advice that you can use outside of this presentation. Just a little bit about me. I have been an attorney now for 20 years. I have a law firm that focuses on
Yes,
real
come
estate
here.
and business litigation. And basically what we do throughout Southwest Florida is help realtors and their customers get through the closing process. And when things come up, whether it's probate litigation, estate planning, we help them with that. I also own a title company, Paradise Coast Title and Escrow. So if you
Microphone
have
is
any
hot.
closing service needs, please reach out to me anytime. My cell phone number is on the screen. So today we're talking about NABOR inspection. So it's the regular NABOR
Okay.
contract. And we have a few
Yours.
initial thoughts that I want you to keep in your head as we go through the slides today. Remember 15, 5, 10, 5.
Close
Those
that
are your
down.
deadlines, and we're going to talk more in detail about them. You get 6 inspections in the NABOR contract, so it's more comprehensive than the FAR contract.
Yeah.
Make sure you're paying close attention to your deadlines, or your buyer could lose their inspection rights.
What it
Interestingly,
on?
the NABOR contract on the seller side is very similar to the as is, in that the seller really
Continue it out.
doesn't have any obligation to make repairs, but then they give the buyer an out. And we'll talk about that. If the seller does agree to repair defective items, then their
I'll scream
exposure is
bigger if you want.
unlimited
Excuse me,
because
Sam.
the
Sam.
yep, sorry,
Sam.
something,
Someone.
Kathy,
Janice is
someone
not
unmuted.
muted.
Oops, I'm mute people. Sorry. Yep, stay muted unless you have a question. So the last point I'll mention just to get started today is that the buyer only gets one bite at the apple. They cannot make multiple inspection requests, but for permit and unpermitted improvement requests, they get a little bit more time, and we'll talk about that as well. So let's dig right into the inspections. In the NABOR contract, you get the 6 inspections. They are your systems and equipment, your radon gas, your lead-based paint, termites and other wood-destroying organisms, mold, and then your open permit, unpermitted improvement inspections. And we're going to talk in detail about each of these, moving fairly quickly because we don't want to waste a lot of your time this morning. And we like to keep these brief. So first up, let's talk about the systems and equipment. What do you get to inspect? Well, pretty much the entire property, all appliances, equipment, fire sprinklers, irrigation, well, septic, heating, cooling, all the things listed here on the screen. And I will tell you this as we talk about them, working condition. The systems and equipment should be in working condition, but what that means depends on which specific system it is, and I'll get to that on the next slide. But also know that no cost to repair or replace any system or equipment item can exceed the fair market value as if that item were in working condition. So in the NABOR contract, you don't get new, you get working condition. So if the washer or the dryer doesn't work, or the air conditioner is not properly cooling, you don't get a new washer or dryer or air conditioner. The seller just puts it in working condition. So what exactly is working condition? Well, for systems and equipment, they must be operating in the manner designed to operate. So the air conditioner, depending on the brand, should be cooling to 16 to 22 degrees. Then if it doesn't do that based on the manufacturer's specifications, it's a defective item that the seller needs to bring into working condition. That means it's cooling. Same thing if your water heater is heating water, but it's old and rusty, it's in working condition because it's heating water. So you don't get to fix the water heater. Now, roofs, ceilings, interior walls, doors, foundations, swimming pools, spas, pool decks, all those things are working condition if they're structurally sound and watertight and free from wood rot. Notice the roof, ceiling, and walls and doors need to be free from wood rot. So that's always a big point of contention when you see rotting around the soffits or around the garage door, around the front door. That under the NABOR contract should be fixed. Similarly with seawalls, docks, the pool, and the lanai enclosures, they need to be structurally sound. So I had a recent case where the support structure of the pool cage was loose, and it's just those wires that hold the pool cage up that cross the pool cage in certain places, and we determined that those were structural issues, and the seller had to get those tightened. So that's working condition. What are cosmetic conditions? Well, those are aesthetic imperfections that do not affect the working condition of the item. And the contract is fairly specific in that it includes corrosion, tears, worn spots, discolorations, minor cracks, although I'm not sure what a minor crack in a window, door, driveway, sidewalk, or pool deck are relative to a major crack. So there leaves a little bit of interpretation in the contract, in the NABOR contract, for what's a minor versus major crack. Things that are really get different from the FARBAR contract are the curling, worn shingles, and limited roof life and cracked roof tiles. If there's no structural damage or leakage, then your roof is in working condition. Why does NABOR do that? Because as long as it's not leaking, then cracked tiles and things like that, or curling shingles, would be considered cosmetic because the roof is not leaking and it's designed to keep water out of the house. It's an aesthetic imperfection. And the seller is not obligated to take any remedial action or grant a credit in lieu of remedial action for any cosmetic conditions. A lot of times you get these inspection reports, and I'll show you the inspection election form in a few minutes, and people will want cosmetic items dealt with, and we're going to talk about how to deal with that in the proper way when I show you the form. The next item is radon. If radon appears inside the property above 4 picocuries per liter, then you have a defective item for radon, and the seller would have to install a mitigation system or otherwise mitigate the radon in the property. And then typically you don't do a radon retest, but if you read the contract and the walkthrough provisions, the buyer could do a new radon test as part of their walkthrough, although that gets a little cumbersome and it's not entirely clear in the NABOR contract that you can do that. Typically, when I'm working on a transaction and I have either party, the buyer, the seller, we work together to get these issues resolved so you don't have a big fight. The next inspection item is your lead-based paint. So the lead-based paint, you don't see a lot of action with this, although houses built before 1978 do require the lead-based paint addendum to contract. And if you did discover lead-based paint, the seller would need to remove or contain it in accordance with federal guidelines, which can be very cumbersome. Next up is your termites. We do see more and more termite issues in properties. And if you have an active infestation or visible damage caused by an active or past infestation, notice I said active or past visible damage, it needs to be repaired. That may require tenting. The seller has to repair the past visible damage, and it's resolved when all of the damages, the termites are killed and the damage has been remediated. Up next, we do see a lot of mold issues under the NABOR contract, and the NABOR contract has a specific test. The presence of toxic or pathogenic molds on the inside of the property has to be greater than the amount measured on the outside of the property. This is an interesting test because if you smell mold in the property or you see visible mold in the property, if it's in a place where there's a lot of mold outside the property, even though you see or smell it inside the property, you may not have an obligation to repair it because it's measured inside versus outside. The other thing about the NABOR contract is that Penicillium aspergillus and other allergenic molds are specifically exempt in the contract. They are not defective items. So you might get a mold test that comes back and says you've got the high presence of penicillium in your property, and the seller does not have to take remedial action and the buyer does not have an out. So what do you do with the buyer who's got a mold sensitivity? Well, if you've got a mold sensitivity, this can be a big issue for your buyer. So NABOR has created an allergenic mold addendum, and you need to ask your buyer, are you sensitive to mold? If they say yes, then you will want to use the allergenic mold addendum, and you'll get any Penicillium aspergillus or other allergenic molds cleaned up as part of the inspection process. The last inspection item that we're going to talk about today, our sixth item, is open permits and unpermitted improvements. And it's what you think it is. Any void, expired, issued, open, or under review or other permit which has not been finalized, completed, done, closed out is an open permit. And if they find unlawful or non-conforming structures or existing violations of local ordinances or codes, all of those items are unpermitted improvements and open permits and can be remedied under the contract. So it's interesting for the inspections, you have a certain amount of time to get the inspection election done, and we'll talk about that in a second. But the open permit, because it takes longer to get that report back, the NABOR contract specifically says that you have, if you start your search process, contact the county government or the city government within 5 days of the effective date, you get an extension to make the permit election, even though you have to make your other permit inspections within 15 days, followed by the 5 days to get the reports together. You have extra time to get your open permits done under the NABOR contract. So let's talk about your inspection election. You get up to 15 days. You can set it for longer or shorter, but 15 days is the default in the contract to do your inspections. In the NABOR contract, you then get 5 additional days to look at the reports, figure out what you want to ask for, and then you must give all of the reports that you want to make an election on to the seller. And the buyer has 3 choices. The buyer may have the seller at the seller's expense repair defective items. The buyer can receive a credit in lieu of the remedial action from the seller, or the buyer can request a combination of remedial action and a credit. If you ask for a credit, again, you only get the cost of remedial action. You do not get a new water heater or a new air conditioner. You get a fixed air conditioner, a working condition air conditioner. And so you have to be mindful of the amount of the credit when you talk to your contractors, and you have to use licensed contractors. So the HVAC guy's got to be licensed. You need a plumber for the water heater and that sort of thing. Licensed contractors, when you talk to them, you need to say, what does it cost to fix this item and get it working? Sometimes they want to sell you a new air conditioner and they say, oh, we can't get this fixed. Sometimes they really have to give you a new air conditioner because the code requires it. And then you have to have a conversation with the seller about what's going to happen and whether they're going to accept the election or not. If the buyer does not make an election, they take the property as is. You cannot request that association property be fixed. So if you're like on the 3rd floor of that condominium building and there's a roof leak above you, that's an association problem coming through the roof. it's not the third floor condominium owner's problem to get the roof fixed. And that can be a contentious issue. We have that issue quite a bit. And again, you get one election. All right, before I switch over and show you the forms, does anybody have any questions so far? You can unmute yourself if you do. Okay. If you do have a question, just unmute yourself and shout it out.
Sam, I have a question about,
Yeah.
the permits. If it's
Sam, I
an
have a
unper-
question.
Oh, one at a time. Bob, go ahead.
if you go into a condo and you see it has a new kitchen or bath, but the people say, we don't know anything about it being permitted. Do you just go to the county, and if it shows up that there's no permit at the county, but you see the new kitchen when you visually look at it, what do you do at that point?
You would make an election on the inspection election form, which I'm showing on the screen right now. I'm going to zoom in on here. And you would click the box for unpermitted improvements, and you'd pick whether you want a credit or remedial action. And remedial action is they have to go out and get permits. They may need inspections, they may need plans. You can, if you have a major project that's unpermitted, you have to get it permitted, and that can be a huge undertaking for the seller.
Thank you.
Yep.
Sam,
Someone
on
else had a
that,
question.
if it's unpermitted and it was disclosed to you on the seller's disclosure, does any of this apply?
That is a great question, and the answer to that is no, because one of the things that you get in the NABOR contract is if the seller discloses any of the issues that could be inspection items prior to the buyer signing the offer, then the fact that the buyer, quote unquote, discovers it in the inspection process doesn't matter. It's not a defective item. That's a great question. When the defective item is disclosed up front, then the seller is not obligated to fix it, and the buyer does not have an option to terminate the contract for that item. I saw another question.
So
Sam,
Sam, if a buyer signs,
Hold on. I think Gina was next. Go ahead, Gina.
Thank you. What I was going to ask is, let's say that there was an elevated level of mold or radon, and the buyer said, "This is so scary to me. I don't want it remediated. I just want to get out of the contract because I am so afraid of this." What would happen?
So the NABOR regular contract, Gina, does not give the buyer an option to terminate if they don't like what they find. That's the as-is contract. So the buyer would have to go through the inspection process, and they would have to give the seller the opportunity to remediate the mold. Of course, if it's a major project and the seller can't get it done, then you have an escrow, but people have to be reasonable throughout the whole process. But technically, the buyer does not have an out if the seller agrees to remediate.
Thank you.
Yep. Kathy?
Good
Kathy, do you
morning.
have a question?
Yes, good morning.
Morning.
Regarding the permit process, Sam, when
Yep.
you get when you start a file, when you automatically start looking at the permits, correct?
We pull a lien search, which includes the open permits and other issues right away. It's one of our first steps. That's right.
So, as an agent, we're working with the inspector, we're getting all of the buyer's election ready. And oftentimes, I'm still wondering if there are any open permits. Do you typically send an email to your agent saying all clear on
We
the open
send an
permit?
email when we receive the permit search back to both realtors and the parties saying that either there are issues and we're going to get a resolution report from the county, or there are no issues. That's right.
Thank you.
Yep. Other questions?
Sam, if a buyer signs the seller's disclosure prior to or post submitting an offer, are they then in fact accepting any
So
of
the seller's disclosure, if you use the NABOR seller's disclosure form, And I should have put that in my presentation, but if you use the NABOR seller's disclosure form and the buyer signs it prior to signing their offer, then the seller would not be obligated to make the repairs that are listed in the disclosure. So if you, for example, disclose that the air conditioner doesn't cool to the required temperature, and then the buyer comes back with an inspection election and says they want the air conditioner fixed, the seller would say, no, I told you about that before your offer. I don't have to fix that. And the buyer would not have an out.
So I have a question regarding that.
Yes, ma'am.
What if on the disclosure, it says something, can you write in the offer that buyer still would like a roof inspection, say?
Well,
Even
the
though
buyer can get the inspection, but they couldn't get it fixed. If, for example, the seller disclosed that the roof leaked, the NABOR contract presumes that you've read the seller's disclosure if it was given to you, and that you made an offer commensurate with what the seller's disclosure said. So if it's $1 million property, for example, and you're in Naples, and it's $1 million property, and the seller puts on their seller's disclosure roof leaks, the seller should not expect $1 million for the offer, and the buyer should make an offer that's commensurate with needing to replace or fix the roof. That's kind of how the NABOR contract is set up to work. It's an interesting system, but that's what it is.
okay, so you can't actually even ask them to let you
You
have
can
that.
always ask, but the seller would
doesn't
not be obligated to make the repair, and the buyer would not have an out if the seller said no.
Okay, thank you.
Yep. So looking at the screen, you're seeing the inspection notice, the buyer's election, seller's response. It's often referred to as the BESR, which I think is a funny name, BESR, BESR, buyer's election, seller's response form. On this form, you fill in your buyer, your seller, your property information at the top. Then in part 1, the buyer checks the box for all. They could check 1, 2, 3, or all of 5 of these inspection elections. And then you go to part 2 and you pick, do you want a credit, or do you want remedial action, or do you want a combination of a credit and remedial action? If you choose a credit, you need to write the amount of the credit into the box, into the blank here in part 2, line A, and notice what it says. Closing credit in the amount of X, which is equivalent to the estimated cost of remedial action identified for the identified defective inspection items as evidenced by the attached written estimates, proposals issued to buyer. So the buyer needs to go out, get estimates, and they need to figure out how much the cost of remedial action is going to be, and then they can request that as a credit. Again, they can't ask for new, they get remedial action amounts. And then the seller can either accept, reject, or counter the buyer's proper election. If the seller accepts, then they agree only as to defective items and not as to cosmetic conditions or other inspection items. So if I just go to my next slide real quick, if I can get this to work. There we go. So this is the notice that attaches to the inspection election, which is the list of systems and equipment that are defective. So your buyer writes down makes a list of all the defective items, and then the seller has to review the items. And remember, they're only obligated to fix defective items, not cosmetic items. So what I do, because buyers often will put cosmetic items on this list, is I ask my seller to cross through the item, initial it, and then sign the inspection election form and return it to the buyer and say, I'll fix these items, which I agree are actually defective under the contract. Okay, I see a question in the chat from Jessica. What if the seller disclosed a minor roof leak was repaired and a new leak is found during inspections? If you find a new leak during the inspection, Jessica, that would be a defective item. So if the seller disclosed that a minor leak was repaired, suggesting that there is no leak, and then the new leak is found, that'd be a different item from what the seller disclosed. And so I would think the seller would have to fix that if they agreed to remedial action.
Sam,
Yep.
was there a little red notification on top that said, don't use this with the as is? What are you supposed to use with as is if not this one?
So that is also an excellent question about the as is contract is designed for the buyer to take the property as is. So there is no election. Now we all know that with an as is contract, what you're really doing is opening the door to further negotiations once the buyer has completed their inspections. At that point, you would need to use the blank NABOR amendment form, and you would write into the amendment what the seller is agreeing to repair. You would need provisions in there for what happens if it is repaired after closing. If the seller doesn't get it done in time, will there be an escrow? All the things that are in the standard contract that are not in the as-is contract, you would have to find a way to include them in the amendment form, which means as a realtor, you need an attorney. You really cannot, as a realtor, be writing up inspection election processes and procedures. That would be very bad. Any other questions on these two forms? Okay, so let's talk. Yep, go ahead.
I just put it in the chat. What about safety items? Are the sellers required to repair those?
Sellers are not required to make any repairs in the NABOR contract. The FAR bar regular contract, they're required to make repairs that are found that meet certain thresholds. But the NABOR, the seller, even if it's a life safety issue, the buyer can notify the seller, and the seller can say, I'm not fixing that, and then the buyer has the opportunity to terminate. So let's talk about completing remedial action. The seller has to make a diligent effort to complete all remedial action prior to the closing date. If they do not, then we have a process for giving a credit where the seller and buyer can negotiate a credit, or the seller has to escrow, and it's not really an option. The seller would escrow 200% of the estimated cost of completing the remedial action, and that amount of money goes into escrow with the title company. And the other thing is, if the seller agrees to complete remedial action, there's no limit on their liability. They have to complete the remedial action. They may have to tent the WDO, the termites. They may have to get a new air conditioner if the air conditioning company says it cannot be repaired due to like a code issue with the new Freon or something. So the escrow sum is also not a cap on the seller's liability if they agree to remedial action. So, and there's a lot of other little things that we could be talking about. I wanted to keep this presentation brief, but if you have questions, you should always feel free to shout them out or text or email me separately. One last thing before we open it up to all the questions is the walkthrough inspection. So you get 4 inspections, we'll call them, at the walkthrough. You get to make sure the seller completed remedial action. You got to make sure that everything that's supposed to be in the property is there. So if it's furnished, for example, if it's not supposed to be there, you got to make sure that everything's been removed. The property should be free of debris, it's broom clean and free of debris. And then you got to make sure the seller has performed maintenance obligations and any remedial action obligations. This is where I want to mention that if you needed a retest for radon, or you wanted to bring in your inspector to have another look at the property, then this is where that would happen at the walkthrough. There is no re-inspection in the NABOR contract, say after the remedial action is complete. If you want remedial action, and many people do, we need to come up with additional terms in the other terms and conditions to allow that. And you can call me and I'll help you write that. One thing I want to point out, realtors really should not be doing walkthrough inspections on their own. Bring the inspector back, have your seller be there. I'm even remiss to say that you shouldn't have video walkthroughs because you might miss something that's important to the buyer, and then the buyer comes down for the first time and they could be upset with you because you didn't show them, you know, whatever, some baseboard was loose or something. So be very cautious about doing walkthroughs for your customers. There's a lot of other things that we could touch on and talk about, of course, in the NABOR contract, and there's a lot of permutations to inspections. I'll take as many questions as you have. I see Jessica put one in the chat. If the buyer selects to have remedial action, is the seller required to repair by a licensed company, or can the seller repair themselves? Jessica, that's a great question. You have to use licensed contractors. Now, if it's a handyman item that does not require a license, like change a light bulb or change the air filter or something simple, then the seller can do it themselves. But if it's fix the air conditioner, fix the water heater, fix the appliances, you would need a licensed person. Other questions? I know there's a lot in the NABOR contract, so if you have questions, you can always email or call me anytime. Anybody else?
Sam, what was the fourth inspection for during the buyer's walkthrough? I didn't catch that. I'm taking notes. Four was, oh,
And
the
I'll
maintenance
send these slides
update.
out, and all this stuff will be on my YouTube channel here in a couple hours. But the seller, make sure the seller performed their maintenance obligation. That is, if the property has a problem while you're under contract, the seller has to fix it, and the buyer can make sure that it's fixed. So if the pool heater goes out, you know, during the inspection, which has happened to me, then the seller would have to fix that because the pool heater was working when the contract was signed, but then it stopped working during the contract closing process, so the seller has to fix it.
Sam, how do you feel about the pool? I mean, to disclose, to uncover any leaks in the pool is like impossible during a one look quick inspection.
Yes, that is very hard to do. It also is fairly easy to detect after closing if the seller should have known about the pool repair leak, because pools typically don't just start leaking really badly. So that would be that brings up to me Johnson v. Davis issues quite a bit. If the seller, if something immediately breaks or appears to have been broken after closing, I question whether the seller knew about it immediately. So that's how you would handle that.
And do you typically recommend that we use the walkthrough document where the buyer signs off on the
Walkthrough
inspection?
document, which one is, the NABOR doesn't provide a walkthrough document.
Maybe it's a John R. Wood form. We have a form that we have the buyer sign at the walkthrough saying
I think that's a good practice, that the buyer saw the property, they accepted the property, they're okay with the property. I have not seen John R. Wood's form, but I think that's a good practice for you to, in terms of, you know, just making sure that you don't get sued because you said the property was fine when it wasn't. Have the buyer sign off is a good good practice.
thank you.
Hey, Sam.
Sam, for
Hold on, I think Mike is next. Go ahead,
Hey,
Mike.
You mentioned, you know, the issue on the seller response of cosmetic items versus items not in working condition. The question I have is, when an improper election is made, you had mentioned scratching it out, you know, you line it out and then respond that way. But then does that also give the buyer the opportunity to terminate? And where's the line for that? You know,
I would argue that it does not give the buyer the opportunity to terminate. I would put in my cover email back to the buyer's agent. I said, I would say something like, I lined through the inspection items that you listed, which are cosmetic, and I would check the box here in part 3A, and I would reference the language that says seller accepts and agrees to buyer's election in part 2 above as to defective inspection items only and not as to cosmetic conditions or other inspection items. And Mike, I know you and I have talked about this in the past, but my reasoning is I want to keep the deal together and as non-contentious as possible because the parties have to work together to get the inspection items done. But if the buyer insists that certain items need to be fixed or they can terminate, then you may need to go the lawyer route and send a letter and do those sorts of things. But as an initial matter, my thinking lately has been if you get an inspection form that's got remedial action or a credit, and the seller has sent over this form and they've put information on the form that's clearly cosmetic, I just line through it, initial it, and then in my email back to the buyer's agent say, we'll fix all the defective items. Oh, by the way, the rusty water heater that's not leaking and actually heats water is not defective.
Gotcha. Okay, thanks.
It's it's kind of a friendly way to handle it. If the buyer is being a real difficult person and you've got the seller, we may need a letter from an attorney and we can provide that if needed.
Thank you.
Batya, I think you had a question?
Yeah, so I had, if the mold addendum's used for that penicillium, do you have to prove that the buyer had a mold allergy?
No, that just says, that just removes that line from the contract and makes penicillin, aspergillus, and allergenic molds defective. You do not need to prove their sensitivity, no.
Do you think they'll ever take that out of the contract? Because that's a very dangerous mold to have in excessive amounts. Why would
I
they?
hope they don't, for the simple reason that it's everywhere and we wouldn't
Yeah.
have any real estate transactions without that line.
Gotcha.
I know it's very contentious and you have to be cautious of that with your mold sensitive customers, but there's mold in every property. It would be a major problem. We've debated that at the Legal Resources Committee for years. I've been on it now 12 or 14 years, something like that. And it comes up every revision period and we come to the same conclusion.
Sam, on the seller side, you're receiving a contract. You get notice of that. If you haven't already somehow conveyed the disclosure form that the seller has filled out, can you predicate the acceptance of the offer on receiving the signed disclosure from the buyer?
I would absolutely do that. Yes.
Okay,
Yes,
just wanted
Marcia.
to
If I
be sure.
if I got a regular NABOR contract and my seller had prepared a seller's disclosure form and I knew that it contained, issues that the seller was not going to want to fix, I would reject the offer, send the seller's disclosure form to the buyer's agent, say, have your buyer sign this prior to resubmitting their offer, just to make sure that I met that line in the contract that said this buyer signed it prior to making their offer.
Or could you simply communicate to the other broker or agent in this case, that there is a form in existence, and just send it to them by way of notification in the listing under private remarks, some way
Well,
to.
the best practice, Marcia, is to have your seller's disclosure in the MLS.
Yes.
And in your private remarks, say, please submit your offer with the signed inspection or seller's disclosure so that I know it's been done.
Thank you.
Yeah, that's your best practice. Okay, Bob has a question. If buyer does not sign seller's disclosure, but seller discloses the HVAC is not working, then the HVAC is a cosmetic item at that time. So Bob, the contract and the seller's disclosure all say that the buyer needs to sign off on the disclosure that they've seen it. So if you send an email to the buyer's agent and say, oh, by the way, the HVAC is not working, you at least create the argument, but the best practice is get that buyer's signature on that seller's disclosure. Other questions? So my original goal for these presentations was to keep them to 30 minutes. They're closer to 40 minutes, which we're coming up against. Unless there are any other questions, I'm going to sign off and say thank you very much. You can always reach me at the information on the screen, and this will be posted to my YouTube channel shortly. Thank you all very much for coming today.
Thank you.
You're very welcome.
Thank you